start with the dying declaration. Dying declaration can be found in 26, section number 26 of BSA, Bharatiya Saksha Adhiniyam, the act that is replaced the Evidence Act. Mostly when discussing this, predominantly the concept is going to remain the same. The only difference that we can find is the difference in the numbers, the section numbers, and the sequential order is the only thing that is different from the old act to the new act. So section 26 of BSA, dying declaration. Now these exact words in the same order have not been written down in the section. Dying declaration is something that is colloquial. People use it outside of the court, inside of the court, but it is not an official term for it. But then in the section there is a lot of, this very section is very big. There is a lot of things that have been mentioned in the section, which I am going to be explaining anyways. So quoting the section would be a moot thing to do, because this session, half of this session anyway, is going to be all about that section. And after I am done explaining this section, I will try and provide the reading material which will contain the excerpts from that section. Right. So before we get into what dying declaration actually means, we should get into what the word witness means according to the act, and what is the meaning of the word witness and what is the meaning of the word hearsay. Now, a witness is a colloquial term that everybody would understand, even those without having a legal background would understand what a witness is. Somebody who has seen something happen is a witness, but then the act says it differently, and since we also have to cover the act at a later point of time, I will go into a lot of detail about what a witness means when we cover the act. But right now we will get into what we need to understand with respect to dying declaration, what a witness is. A witness is someone who was there at the scene of offense in the criminal sense of things, because dying declaration does not only cover the criminal aspects of law, it also covers civil aspects of law. It also deals with someone who has gone out of country, who cannot come back within reasonable time, or all of those things have been mentioned in the section, which we'll get into eventually. But right now, the word witness means someone who was there, someone who has touched things, someone who has heard it for himself, someone who has seen it for himself, something that has happened. He was there, he has seen it, he has touched it, he has sensed it with his senses, and then he has formulated his own opinion about it because he was there. That is a witness essentially. But now, say a particular witness was there at a scene of offense, he has seen breaking in or a theft or something. Let's call him X. X now has seen something happen, he has gone back home and he has told his wife, for example. Now, Mr. X does not have any reason to lie to his wife, so he was being extremely truthful, let us assume, and his wife has heard all about it, and his wife is the one who has approached the police or the court or anybody, and his wife is now ready to give testimony. But unfortunately, his wife's testimony is not admissible in the honorable court because his wife was not the one who was present at the scene of offense. Mr. X was the one who was present at the scene of offense, and his wife has heard him say what he has seen. So his wife's testimony is not admissible. Whatever statement his wife wishes to make in front of the honorable court is not admissible because it is termed as hearsay. Now, this very peculiar section, this very peculiar concept of dying declaration flies right in the face of a witness, a value of a, not a value of a witness, the admissibility of the statement given by the by someone who is not a witness, technically speaking. And it also flies right in the face of the concept of hearsay because technically speaking, someone has heard someone else, someone who has seen something for himself is telling someone else what he has seen, and that someone else's testimony is considered during the time of trial, because unfortunately that someone who has seen it for himself is no more. That is called dying declaration. It is an exception to the concept of hearsay, and it is an exception in a manner of speaking to the concept of witnesses. Now the concept of dying declaration starts with the fact in issue. There is something called facts and facts in issue. All of these things will be discussed while we are discussing the Evidence Act, the Bharatiya Shiksha Adhiniyam at a later point of time. But colloquially speaking, a fact in issue in the court, I am assuming that everybody understands what a fact in issue is. Something that is supposed to be gotten to the bottom of with respect to the trial. That is the fact in issue as far as this section is concerned. When the cause of death of a person is a fact in issue, that is when this section kicks in. And death does not actually mean death. Death encompasses many other things in this section that I will come to shortly. In this very session we will discuss that, but cause of death should be a fact in issue as far as the dying declaration is concerned. And for the section to kick in, this is what is supposed to be a fact in issue. And evidence is needed with respect to the cause of death and the circumstances leading to the death. So say the evidence is needed, and that evidence is what is given by someone who is not technically a witness in this case. Now the expectation of death, whether or not that person who was dying while he gave a declaration is called a declarant, whether or not he was expecting to die at that point of time before giving the statement, or after or during giving the statement, whether he was expecting to die or not is of no consequence here. And also the nature of the proceedings, whether they are civil in nature, criminal in nature, all of these things also have less than adequate bearing with respect to when this section is valid, when this section comes into the picture. So expectation of death is irrelevant here, more or less, and nature of proceedings are also irrelevant here, more or less. Now who can be called? Say there is a person who is being given a declaration. Who is that person and what kind of people? There is a hierarchy to it with respect to the admissibility and the credibility of the information given by that person. Number one is magistrate. If a dying declaration is given to the magistrate, it has got a lot of bearing. In fact, it is given the highest level of importance, because it is a magistrate and he has got a lot of other responsibility, mostly because of the importance that is given to the statement that is given to the magistrate. Number two, a medical officer. The doctor who is in charge of treating the declarant, or the doctor who is in charge of all of the documentation that is required, that doctor, if that doctor is given the declaration, that is given secondary importance. Then come the relatives, the kith and kin and the friends. Anybody in the immediate social circle of the declarant is given importance. The last degree of importance is given to the police officer who is trying to get a dying declaration out of the declarant, because he might be a witness, he might be colluding with someone else, we don't know. And the law always assumes that the police officer is always after the conviction. Therefore checks and balances are required, and therefore the least amount of importance is given to the police officer who in front of whom the declarant is giving the dying declaration. So not witnesses, or technically not witnesses, include magistrate, the statement given to the magistrate, and the magistrate's recording of the statement rather is given the utmost importance. Then comes the medical officer, then come the relatives, the kith and kin and friends, and the immediate social circle of the declarant, and then come the police. Now, when I said dying doesn't really mean dying, dying includes in this section, at least in this context, dying also means not just dying, it can be already dead, it can be that the person cannot be found now. Whoever has given the declaration, quote unquote, cannot be found now, or that person has become incapable of giving evidence. He has been medically, clinically, or psychologically or mentally rendered incapable of giving evidence. Maybe he is not conscious, maybe he is not in a mental capacity to be able to give a statement or of comprehensive thought. Maybe anything might have happened to him which may be considered an accident, or maybe not, maybe a medical condition, we don't know. He has become incapable of giving evidence. Then one more thing is that his attendance cannot be ensured without an inordinate delay or extreme cost, according to the Honorable Court. This one point is dependent upon the Honorable Court's discretion, because while the trial is going on, while the proceedings are going on, if that someone has already given a statement to somebody who is not a witness, say a magistrate or anybody, he has given a statement and he has gone, say, out of country, or he has been detained out of country, or maybe there might be any reason for his not being there. And if the Honorable Court, using its discretion, decides or comes to the conclusion that it will take a lot of time for that person to maybe come back to where the proceedings are going on to give his fresh statement, or it might cost a lot of resources in the endeavor to bring that person back to give his statement, that is dependent upon the Honorable Court's discretion. And if according to the Honorable Court one of these two things is the case, then that also comes under the dying declaration section. As I've already told the participants, the section is not called dying declaration section. It is just that in the event that person cannot be found, in the event that the person is dying or dead, in the event that attendance of that person cannot be procured, all of this is written in the section. I shall share the section also with you. It is going to be available in the reading material. Now, the declaration part of it, we examine. The declaration cannot be about anything and everything. It has to have certain quality to it. The quality of the statement has to pertain to the cause of death. Am I audible? Hello? Am I audible? Yeah, I'm thinking I'm already right. So the quality of the statement is what I was discussing. The quality of the statement meaning the statement has to pertain to the cause of death and the circumstances leading to the death. Those two things determine the quality of the statement. And based upon this dying declaration as a concept is dated, it is very old, and right from the Latin speaking times, the concept of this originated from the Latin speaking times, which said that a man while dying is incapable of lying, or will choose not to lie because he has got nothing to worry about as far as consequences are concerned. He is already dying, why would he lie? So there is a Latin statement to this. It is called nemo moriturus presumitur mentire, which means a man shall not meet his maker with a lie in his mouth. जो बंदा अपने मालिक के पास जा रहा होता है वो मुंह में झूठ का मजा लेके नहीं जाता है. That is the concept behind this dying declaration. Now, this concept being as dated as it is and being as general as it is, has faced a lot of criticism from a lot of places and from a lot of people and a lot of thinkers. Mainly the criticism is that this is not always true. Even a person dying can hold a grudge. Even a person dying may seek to you know may seek to lie to better his purpose. It's not clear. Right, give me 1 second. Is it audible now? Am I audible now? Slightly better. Give me 1 second. I'll try and fix the voice problem. Right, how about now? Am I audible to the participants now? Right. So we were discussing the Latin phrase Nemo moriturus presumitur mentire, which means a man shall not meet his maker with a lie in his mouth, meaning जो बंदा अपना मालिक के पास जा रहा होता है वो मुंह में झूठ का मजा लेके नहीं जाता है. It is a dated concept. It is a very old concept, and therefore this concept has met with a lot of criticism. Mainly that criticism is that it is not always true. It is legal fiction. A man can lie while going to meet his maker as well, while dying as well. He may choose to lie. That is the main criticism. But the origin of the concept of dying declaration is this Latin phrase saying that a man shall not meet his maker with a lie in his mouth. He is dying anyway, so why would he lie? That is the concept behind dying declaration, and it has stuck despite the various other attempts to make different interpretations of this concept. As a concept has stuck. Right. What is the relevance of a dying declaration with respect to criminal cases? What is the importance that is given to the dying declaration with respect to criminal cases? A dying declaration has got corroborative value, number one, and number two, dying declaration is also more important than having just corroborative value. A question of how did the death happen? Oftentimes while during trial, oftentimes it happens that how the death has happened will become more important than an actual question, because it might determine the proceedings as well. So the dying declaration is one of the things that can help out the magistrate, the judiciary, to understand how exactly did the death happen. Now, what is the role of the investigative agency in all of this? What is the role of the police? Although the police has not, the actual report that has been filed, that is filed by the police after hearing the dying declaration given to the police itself, although that has not been given as much value as a report filed by the magistrate, the police has got a lot of responsibility with respect to collecting a dying declaration. The role of the investigative agency obviously is doing the paperwork at first, documenting and filing properly the dying declaration. Although the first preference is given to the report by the magistrate, the declaration given to the magistrate, ensuring that the statement has been given voluntarily is one of the responsibilities of the investigative agency. There should be no coercion, there should be no undue influence. Maybe this person X is dying, his daughter, or there is someone who is present during the dying declaration who is trying to unduly influence the person who is trying to give the declaration. The investigative agency has got the responsibility to ensure that while giving the dying declaration, it has to be given voluntarily, and it has there should be no undue influence or coercion. Now, ensuring consistency is also one of the responsibilities that has been given to the investigative agency. Now, consistency, what do I mean by it? Usually, when a person is in the hospital giving declarations or making statements, he has no idea that he is about to die. Maybe he is expecting to die or not, and it is not. It is more usually than unusual. It is more usual than unusual that he gives more than one statement, or that he tries to change his statement, or that he is not comprehensive during the first time he gives a statement. He might choose to add some more things as time goes on. Therefore, consistency is what is supposed to be ensured by the investigative agency. Proper documentation is supposed to be done by the investigative agency, and also while receiving the declaration, while recording the declaration, it is imperative that the investigative agency does it in front of independent witnesses, preferably independent witnesses, if not available relatives, if not available medical staff, and only as a last resort a subordinate officer can also become a witness. But then as we were already discussing, the importance that is given will go down when a subordinate officer is one of the witnesses. But in the event of him not finding any independent witnesses or relatives or any medical staff or anything of that sort, then as a last resort, the subordinate officer may also become the witness with respect to a dying declaration. Now, that is the role of the investigative agency, the police officer who is collecting the declaration. Now comes the role of the medical practitioner. The medical practitioner has got a very how do you say it? It's not a peculiar role, but then usually a medical practitioner has got to understand the legality of it with respect to this section, and also with respect to MLC, meaning medical legal case, also with respect to drafting reports and giving post-mortem reports and any other medical reports. All of these things should be corroborated, and the medical practitioner may also be called in as a witness and may be cross-examined. And we will go through some of the challenges that are faced by the medical practitioners. Now we will discuss the role of the medical practitioners. It is to document, number one, document the time and date on which the declaration, on which the declarant has been brought in. Say a person is admitted in the hospital and he is trying to give a dying declaration. We don't know if it is a dying declaration or not, but the date and time on which the declarant has been brought in is supposed to be recorded by the medical practitioner, and the medical practitioner also has to observe the mental fitness and the level of consciousness of the declarant. The declarant might be just rambling. The declarant might not be in a mentally fit condition to be able to comprehensively give a declaration. He might not have a clear chain of thought. All of this is supposed to be corroborated, or all of this is supposed to be observed by the medical practitioner, and he is supposed to give the go ahead with respect to giving a declaration. If the declarant is not mentally fit to give a declaration, such a declaration shall not be admissible, because the medical practitioner also has to give a certification with respect to the mental fitness of the declarant, and he has to fill in all of the other forms, the accident sheet among other things, and registers and other forms after the declarant has been brought in. And he also has to document the treatment that is given to him, given to the declarant, and he is supposed to record the last words of the declarant, and he is supposed to announce the time of death. In case death happens, what happens if the declarant does not die, we will discuss it at a later point of time. it is just the declaration just becomes a statement afterwards, but then a statement given by a witness, that becomes that. But then announcing the time of death in case of death happening is one of the roles of the medical practitioner, and issuing a death certificate also is the role of the medical practitioner. The role of the magistrate now, the medical practitioners, the investigative agency, the police, everybody is on one side, and the role of the magistrate, because the magistrate's report on the dying declaration is given the utmost importance. The magistrate has also got a lot of responsibility with respect to collecting the dying declaration. His opinion is given importance, therefore he has got a lot of responsibility. So it is considered, usually the recording made by the magistrate is the most authentic from the point of view of admissibility in the court. Usually the recording of the magistrate, the report of the dying declaration of when given, when submitted to the court by the magistrate, it has got the most weightage with respect to admissibility. Now the responsibility of the magistrate is to ensure the free will of the declarant. Also, all of these things also have to be done by the magistrate, ensuring that there is no coercion, there is no undue influence on the person giving the declaration. And the role of the magistrate is also to understand better and to have a conversation with the declarant, and to make the declaration slightly more comprehensive and more admissible. The magistrate is given some sort of leeway with respect to this, and he, while doing that, he is supposed to avoid leading or suggestive questions. I will get into what are leading questions, what are suggestive questions while discussing BNSS at a later point of time. These things are all covered during examination in chief and cross examination. Leading and suggestive questions are supposed to be avoided. And documenting personal observations. There is a lot of things that happen while a person is giving a declaration. He might use gestures, he might use a lot of non-verbal cues that the magistrate should be sensitive to. And he also has got the responsibility to examine the fitness certificate, the fitness certificate issued by the medical practitioner. If a medical practitioner says that the declarant is mentally fit enough to give a declaration, this fact has to be corroborated or fact checked at least by the magistrate. Now, coming to the essentials, there is essentials of a valid dying declaration. There is a lot of Supreme Court judgments that have got some sort of an opinion about what a dying declaration should be like. The essentials of a valid declaration is taken from a bunch of the Supreme Court judgments that I shall also be sharing with the group. Now, the essentials of a valid dying declaration is: number one, it ought to be made by a person on the verge of death. Number two, the statement must relate to the cause of death. All of this we have already covered, but as a summary point, I am giving this. A statement must relate to, number one, the cause of death. Number two, the circumstances of the transactions leading to the death. The declarant, number three, this is one of the essentials of for valid dying declaration. The declarant must be certified mentally fit enough to give a declaration. And number four, the absence of undue influence or coercion. And the statement needs to be clear and unambiguous. The declaration should be clear and in precise words and not ambiguous. Then the documentation has to be completed by a competent authority, be it the investigative agency or the medical practitioner. A competent authority who has got who is doing the documentation needs to be competent. Then comes the signature or the thumb impression of the declarant. The statement that has been made, the declaration that has been made, has to be signed off or endorsed on by the declarant, and then that signature should also be followed by the signature of the competent authority that is in charge of taking the declaration at that point of time, meaning after the declarant signs the magistrate should sign, or the medical practitioner should sign, or the kith and kin or the relative should sign, or the police officer should sign. There is different forms of dying declarations. The most common form is oral form. Next comes the written form signed by the declarant. Gestures that are recorded by the magistrate, audio and video recordings, statements that are recorded by the magistrate, statements that may not be comprehensive but statements nonetheless that are recorded by the magistrate, declarations that have been made in front of police officers, statements made in front of medical personnel, and statements or declarations made in front of witnesses. These are the types of dying declarations. Now coming to the evidentiary value of the dying declaration, the admissibility of the dying declaration is equivalent to direct evidence, and in extreme cases the dying declaration, if deemed credible and reliable by the honorable court, carries so much weightage that it can also become the sole basis for conviction without any corroborative evidence backing it. So a dying declaration can also be a sole basis for conviction, provided it is deemed so credible or reliable by the honorable court. The honorable court has got the power to assess the credibility or the reliability of the dying declaration, and also finally the dying declaration can also be used to corroborate other evidences or other statements in the honorable court during the proceedings. Now come more guidelines on the reliability aspect of it. The reliability, as we were discussing, the dying declaration shall be unambiguous, it shall be voluntary, it shall be relatable to the cause of death, it shall be the declarant must be conscious and mentally fit, and it is admissible if deemed reliable and worthy by the honorable court without any corroborative evidence. It can be the sole basis for conviction even. And one of the guidelines also suggests that it has to be recorded in a timely fashion, and it has to be recorded in a proper fashion. And now comes the question of, what if there is more than one declaration by the person who is dying? Maybe at 6:05 he has given a statement, and 6:10 he has given another statement, 6:15 he has given another statement, at 6:45 finally he has died. What of these three statements, and which statement has got more weightage with respect to admissibility? Now, number one, there is also a Supreme Court guidelines. There is also a lot of precedents set forth by the Supreme Court, which I shall share. But essentially, consistency is what is supposed to be looked at with respect to more than one dying declaration. If the statement that has been given at 6:05 is consistent with the statement that has been given at 6:10, is consistent with the statement that has been given at 6:15, then we have no problem. When there is no consistency, then the dying declaration is inadmissible. When there is a lot of difference between the statements given at 6:05, 6:10, 6:15, the dying declaration is inadmissible. But if there is some difference, the latest, most recent statement that has been made, as in when I say latest statement, it also has to have all of these things that make it a credible dying declaration. In that case, the latest dying declaration is given most value and is admissible as the dying declaration. And also with respect to conflict, if there is a lot of conflict, then the declaration is termed inadmissible in the honorable court. But if there is some conflict, judicial intervention is needed, and according to the case and according to the situation at hand, judicial discretion is needed to find out whether the dying declaration that has been given is admissible or not. Right, now we shall discuss MLC. Before we get into MLC, we shall understand expert testimony in Indian courts. The medical practitioners and the forensic scientists and other people who are deemed experts with respect to court proceedings, their testimony, what is the importance of their testimony and how would their testimony shape the proceedings, and what is the procedure that is followed whilst taking this testimony. We will get into all of that. The opinions of third persons when relevant, section 39 subclause 1 of BSA. Expert opinion, when the court has to form an opinion upon a point of a foreign law, of science or art or any other field, or as to identify handwriting or finger impressions. This provides a gamut of people with a plethora of specializations. This casts a wide net. Therefore, I am reading the section out loud. The opinion right now, see, whenever there is a witness that is giving testimony in an open court, his opinion is of little value, because he has seen something, he has heard something. That is all. Essentially, that is what he is supposed to share in the open court. His opinion on that matter is given no importance. But then expert testimony is different in the fact that the expert's opinion is essentially why the expert has been brought in. The expert has not borne witness to what has happened. The expert was not there when it happened, but then due to his expertise in the subject such as foreign law or science or art or any other field, or due to his ability to understand handwriting or finger impressions, or to authenticate certain documents and to authenticate certain evidences, because of his academic qualification, because of his knowledge and his experience, all of these things according to the honorable court are enough for his opinion to matter in the legal proceedings. Now, the qualification and the role of forensic science experts and forensic medicine experts. Knowledge, skill and experience in a specific area is required. Their role is analyzing the crime scene evidence. Say there is a fingerprint or a document or a signature upon a document, all of these things they have to analyze, and they have to let the open court know, the honorable court know. They have to let the honorable court know of the authenticity or otherwise of such an evidence. And they also have to they have the responsibility to maintain ethical standards and legal responsibility with respect to inculpatory and exculpatory evidence. Inculpatory evidence is what seeks to convict the accused, and exculpatory evidence is what seeks to acquit the accused. And they also have to contribute to crime scene reconstruction whenever is necessary, wherever necessary, and the presentation with respect to whatever technical knowledge they have the responsibility to dial it down a bit and present the technical and scientific data as an opinion or in the form of a report in the open court, which is understandable by the honorable court. Now comes the role of forensic medicine expert. They have a role in determining the cause and manner of death, and they have to announce the time of death, post-mortem interval as it is called. They have to have expertise in interpreting injuries and wounds. Say there is an open wound and a knife nearby the body. The police during the inquest will say that this injury has been caused by this knife. Whether that injury has been caused by that knife or not is what the forensic medicine expert has to come to the conclusion with regards to, and he has to file a report with regards to that, and he has to come to the open court when invited to come, when summoned to come in fact, and he is charged with the responsibility of interpreting such injuries and such wounds, and examination of toxicological findings, whether a poison based upon the rigor mortis, based upon the changes that the dead body or antemortem or post-mortem, based upon the changes the body undergoes, and interpreting the changes and saying whether or not a particular poison that has been found in the scene of offense or that has been found with the accused, whether or not that poison has caused such change in the body. The medical, the forensic medicine expert, that is his job. And also age determination with respect to POXO cases, kidnapping, abduction cases, marriage, contracts, all of these things, whether or not a particular person was old enough to have gotten into a contract, or whether or not a particular person is old enough to have gotten into a legally valid marriage, whether or not a crime has been committed by a juvenile. All of these things have to be corroborated by the forensic medicine expert. And also histopathology reports, as we were discussing, whether or not a poison or whether or not a particular injury has got anything to do with the changes that the body has undergone, the changes the tissue has undergone. Study of tissues, I think, is called histology, and histopathology is the study with regards to the changes in the tissue after the change. Now, areas where the expert testimony is solicited is a lot of areas. There is whenever the honorable court is of the opinion that the knowledge base or the experience level of anybody involved, all of those people who are involved in the proceedings, if there is a need for external stimulation, and if there is a need for someone who has got expertise in the matter at hand, then the honorable court will solicit expert opinions. It might be with regards to homicide and assault, it might be with regards to identifying the victims and suspects and poisons and drugs, it might be to analyze DNA analysis when it becomes evidence, it might be to understand ballistics, firearms and ammunition, whether or not the bullet that has been found in the scene of offense has been fired from a particular firearm, yes or no. The magistrate will need some help with regards to whether or not with regards to determining whether or not a particular bullet has been fired from a particular firearm. Examination of bodily fluids, might be blood, might be mucus, might be something else. Examination of those bodily fluids and coming to the conclusion, or helping the honorable court rather to come to the conclusion of whether or not it is admissible, whether or not it is something that is relevant to the proceedings. Skeletal remains examination, digital evidence examination. There is a lot of things that the honorable court might choose to solicit the expert opinion with regards to. Now, there is a lot of cases, there is a lot of case laws with respect to expert testimony. Selvi versus State of Karnataka, about we were discussing this case, but we will discuss this case whilst discussing the acts at a later point of time. Right now I will just share the case names and relevant points with regards to the case. In the Selvi case, the admissibility of narco analysis was discussed, and the court held that narco analysis essentially is where the witness is injected with questionable chemicals, and the reliability of such a statement of that witness while under the influence of such chemicals might not be admissible. So the admissibility of narco analysis was discussed in the Selvi case. Kishan Chand versus State of Haryana, forensic evidence in the chain of custody. You see, when say there is a knife that was available, that was found rather at the scene of offense, that knife has to be properly packed, and that is a piece of evidence that has to follow chain of custody. When there is any breakage with respect to the chain of custody, the admissibility of that evidence will go down. This was discussed in the Kishan Chand versus State of Haryana case. Role of toxicology reports was discussed in the Mohammad Aman versus State of Rajasthan case. Forensic standards were discussed. Handwriting analysis was discussed. Forensic anthropology was also discussed in Satyapal versus State of Haryana. We will be discussing that case really soon. Analysis of firearm evidence, Ram Gopal versus State of Maharashtra in 1972. Firearm evidence, ballistic evidence, whether or not a particular slug, there is a cartridge is the combination of a shell, a bullet and gunpowder, and whether or not that bullet has been fired from a firearm based upon the markings it has from the barrel, based upon the amount of heat the firearm has generated whilst burning the gunpowder. All of these aspects were discussed with the expert during the proceedings, and expert testimony upon the analysis of firearm evidence was discussed in the Ram Gopal versus State of Maharashtra case. There is a lot of other cases. Priyadarshini Mattu case, you might have heard of it. DNA analysis and the admissibility of the DNA analysis. All of these cases, there are a lot of challenges that are faced by the experts giving testimony. There might be issues with regards to evidence contamination, whether or not the evidence has been tampered with. That is a completely different story, but contamination is a very big challenge. Delay with respect to processing is a very big challenge. These are all practical aspects that need to be taken into consideration. The variability of standards across states. A particular lab may do things differently and set some standards with regards to weighing, with regards to the time period, with regards to measurement. All of these standards might differ from state to state, from lab to lab. Inadequate knowledge, inadequate means of interpreting and explaining scientific data. A scientist is a scientist. He goes to court and he says whatever is relevant according to him, but then the court might have some trouble understanding his knowledge, because he is an expert in a certain subject and he thinks everybody understands the subject, but that might not be the case. Resource limitations is one other challenge. Now let us discuss some other cases are there that I was wanting to discuss, but then those cases, it will be better if we discuss them while we are discussing BSA, BNS and BNSS, because we also have to get into certain details with respect to the case laws while discussing sections that are there in BNS, BNSS and in BSA, and I will share the case laws beforehand when I am discussing those cases, so that it is easier for the participants to give their inputs on the matters. That, I think, concludes today's session. We have discussed, a brief recap I will do. We have discussed dying declarations. Which section discusses dying declaration? It is section number 26 of BSA. Dying declaration, these words have not been used in the section, and the dying declaration as a concept is an exception to hearsay evidence. Hearsay evidence in this particular case is admissible because the actual witness is no more, and the dying declaration is given to people who technically speaking are not witnesses, people such as the magistrate, the medical officer, the relatives, the kith and kin, friends of the declarant, and even the police. And dying declaration, with respect to that, dying doesn't just mean dying with respect to the section. It means the declarant may be dead, the declarant cannot be found, the declarant has become incapable of giving evidence, the declarant, the attendance of the declarant might not be able to be, might not be easy to procure without extreme cost or inordinate delay in the opinion of the Honorable Court. The quality of the statement that is supposed to be given by the declarant has to pertain to the cause of death and the circumstances of the transactions leading to or resulting in death. The Latin phrase nemo mortuus praesumitur mentire, a man shall not meet his maker with a lie in his mouth, is the origin of the concept of dying declaration. It has faced a lot of criticism, saying that it is legal fiction. A man might choose to lie even while on the deathbed. The relevance is that dying declaration has got both corroborative value, or it can also be the reason for conviction without any corroboration if it is deemed credible by the Honorable Court. There is a lot of role with respect to dying declaration, a lot of responsibility given to the investigative agency, predominantly to document and file the declaration and to receive the declaration in the presence of witnesses such as medical staff, relatives, and as a last resort, even subordinate officers might become witnesses with respect to the dying declaration, and the investigative agency and the magistrate and anybody taking the dying declaration has got the responsibility of ensuring that the declaration has been given without undue influence and without coercion. The medical practitioner has got the roles and responsibilities to document the time and date on which the declarant has been brought in, to observe and to report the mental fitness and the level of consciousness of the declarant, to certify also the declarant's mental fitness, to fill in all the forms and registers that ought to be filled in, to record the last words of the declarant, to announce the time of death, and to issue certifications. The role of the magistrate: first off, the recording by the magistrate is considered most authentic with respect to admissibility. Therefore, he has got a larger role and larger responsibilities. And the role of the magistrate is also to ensure the free will of the declarant, to avoid the leading and suggestive questions, to make the declaration more comprehensive, documenting personal observations, eye contact, gestures. Can be many things that the magistrate might choose to record, and he is also given the responsibility to examine the fitness certificate issued by the medical practitioner. The magistrate is there as part of many checks and balances that have been introduced to lend some credibility to the dying declaration. There is essentials of a valid dying declaration. It is supposed to be made by a person on the verge of death. The statement must relate to the cause of death and the circumstances or transactions leading to death. The declarant must be certified, mentally fit enough to give declaration, and the statement must be made in the absence of undue influence or coercion. The statement that has been made must be in clear terms and unambiguous terms. The documentation has to be done by competent authority, be it the medical practitioner or the magistrate or the police. The signature or the thumb impression of the declarant has to be taken while taking a declaration in a written form. The signature of the competent authority, be it the magistrate or the police, has to be taken. There is different forms of dying declaration ranging from gestures to oral to written to video and audio recordings to statements recorded by the magistrate, and the evidentiary value of dying declaration is that it has got admissibility that is equivalent to direct evidence, and it can also be the sole basis for conviction if deemed credible enough and reliable enough by the discretion of the honorable court, and it can also have corroborative value that can be used to support or bolster other evidences. There is Supreme Court guidelines. All of this has been taken from various case laws that have been given by the honorable, that have been decided by the honorable Supreme Court. The Supreme Court has issued guidelines on reliability. The statement has to be voluntary, it has to be unambiguous, it is supposed to be relatable to the cause of death, it is supposed to be given by a conscious, mentally fit originator, it is supposed to be recalled in a timely fashion, etc. and etc. If there is a question of multiple dying declarations, consistency is the need of the hour. If the statements that have multiple statements that have been made are consistent with each other, there is no problem. If there is an inconsistency, the judicial discretion is needed in case of conflict between dying declarations. Most in cases where multiple dying declarations are made, most recent dying declaration, a proper dying declaration that has been given most recently, is given preference over the others. Now comes autopsy and post-mortem examination. Now, purpose of an autopsy, the medico-legal cases also include autopsies and post-mortem examinations. The purpose of an autopsy is to know the actual cause of death. There is a couple of things: the external and internal examination. Before the cadaver gets cut, external examination is supposed to begin. External examination might refer to external injuries, the condition of the cadaver, and etc. After cutting up the cadaver, the internal examination is done, visceral examination as it is called. This has got value in determining the cause and manner of death, and also the time of death, depending upon the rate of decomposition or the stage of decomposition that the cadaver is in. The time of death is given, and the findings are documented, and legal requirements are also something that the medical practitioners have to familiarize themselves with. Because they are required to submit reports to the honorable court. There is types of consent with regards to medico-legal cases. There is rape victims, there is assault victims, there is all sorts of people that need to be examined by the medical professional. There is types of consent that they have to familiarize themselves with. There is implied consent, there is explicit consent, there is medical consent, the kind of consent that is needed for maybe having physical contact with the victims by the medical practitioner. And there is legal consent because there is something called right to privacy, and as a medical practitioner, the practitioner has to be in the clear with respect to things like invasion of privacy. Legal validity is given to consent, especially mentally challenged victims or minors. The guardian has to be present with respect to giving consent, especially in sexual assault cases. And some of the challenges were also discussed. Medico-legal experts and forensic experts have to familiarize themselves with courtroom procedures, they have to familiarize themselves with the concepts of cross-examination. They have to balance their ethical and legal duties. They have to deal with legal terminology, just as the judge might find it difficult to understand the medical jargon. The medico also would find it difficult to understand the courtroom jargon. Both these parties have got some responsibility to familiarize themselves with each other's jargon. There you go. Then we had discussed procedure of conducting post-mortem. An official authorization is required to conduct a post-mortem. External examination and internal examination, bodily fluids, visceral samples, and all of these things have to be examined during post-mortem. And then there is the report of the post-mortem containing the preamble, which is essentially the details, the personal details of the deceased, things like date, time, and place of autopsy. And then comes the examination proper, the body of examination, which contains the external examination findings, the internal examination findings, the cause of death determination, the manner of death, time since death, opinion and final remarks, along with the seal and authentication. Then we had discussed expert testimony. When the court has to form an opinion on a point of foreign law or science or art or any other field or anything that is unfamiliar to the honorable court, that needs an expert outside expert opinion, then the expert opinion is solicited. Persons who are usually skilled and knowledgeable in a particular aspect are known as experts. These people have to have knowledge, skill and experience in a specific area. Roles like analyzing the crime scene, analyzing the evidence, analyzing fingerprints, footprints, documentation that has been found in the scene of offense. Even in civil nature, it might be civil or criminal, there is the kind of proceedings will determine the kind of expert opinion that is solicited. That has been today's session. I shall ensure that the reading material and the PPTs are sent over today or tomorrow. I shall ensure that it is shared in the group. Questions? I don't think this is all procedural law. Therefore, it is not really an opinion of anybody. This is the procedure that has been laid down in the law, and we are discussing that procedure. Therefore, I am not really sure what kind of questions the participants would have. Therefore, I think it is better we end the session, and after the participants familiarize themselves with all of these concepts, and after the participants are done reading up on their own, I think then would be a better time for us to get into questions and discussions, right? Especially after us discussing the case laws. While during the sessions that cover the acts, it is then that the discussions will be fruitful. With that, I am ending the session. Thank you very much. Yeah. Very good. Yeah, it is. Regarding your list,